Supreme Court making a decision, yes, you can take your home, and it doesn't have to be for the road or school or something. It has to be for the benefit of the corporate money guys. We make more money if we take your home and put businesses there.
That particular decision was basically involved a rewrite of part of the Constitution itself.
There you go.
And,
there you go, yeah. And I want to, show you this book. We're going to get back to this book later on there. Men in Black. That's why the book is black. And men, not gods, it says here, in the plural. The biggest myth about judges is that they're somehow imbued with greater insight, wisdom, and vision than the rest of us, that for some reason God Almighty has endowed them with superior judgment about justice and fairness. Hey, but the truth is that judges are men and women with human imperfections and frailties. Some have been brilliant, principled, and moral. Others have been mentally impaired, anal, and even racist. How did they become judges under circumstances?
That's right. Politically.
It's buying
Some
justice.
Some you might say literally bought their position.
Yeah. And this goes back into, the history here. This is not fiction. Look at all the criteria in the back of these books here, look at all the stuff here that we get, I can't even go through all this stuff. There's so many things to prove our point out there. Sometimes I bring one book with me and I show all the credentials in the back of the book here to people, and they fold up,
Well, I've seen some writers refer to judges as bandits in black robes.
You have heard that, huh?
Yeah, right.
Yeah. But, see, this is the kind of stuff there that is evidence, all these books here, to the lawyers. What are you guys going to do about all this stuff that's in here? Are you intellectually, knowledgeably capable of debating the issues hereby in question?
Mm-hmm.
They said I was too well prepared.
Yeah, right.
And sometimes all you had to do is to show them all this kind of stuff. When there's dozens and hundreds and even thousands. You got that big book over there and all the stuff that you see here.
Mm-hmm.
We do not come empty-handed out here to talk about things. Is there any judges out there who's willing to come up here and sit here on this table and discuss things with me and Edward and the guest that we're going to have on? Well, I guess we're running out of time.
Yep.
And we're going to have to call it quits for this hour. So the next hour we'll bring a guest on here. Edward, thanks for being on the program, and we'll see you on the next hour, so to speak.
Thank you, Ernie.
You have a nice evening, and thank you for watching our program. You take care. Edward Whitney from Fairfield, Connecticut. Welcome.
Thank you, Ernie.
And on my right is our guest for this hour, Albert Lebrun. And you live in
South Windsor.
In South Windsor, okay. And I am Arnie Engen for Quo Vadis America. Quo Vadis America is a program that is designated to inform the public of what is going on in the United States. What is happening to our judicial system, which is going down the old road here. And tonight, ladies and gentlemen, we're going to get into the subject matter of the judicial system in the state of Connecticut, which is why we have Mr. Albert Lebrun here. You have an issue.
Yes, I do.
You have an issue with the judicial system?
Yes, yes.
Tell me.
My house been attached since 1989 for 100,000.
Yeah, wait a minute now. Let me say, how did you get into this problem that is the result of you being a guest on this program? What happened? One day you didn't have any problems, and the next day you ran into something. What?
I had a place, a business in Stafford Spring. I was keeping 2 dogs over there.
Yeah.
Way back in May 1989, my wife went over there to feed the dog, and she found 2 girls against the building, in the back of some shrub. And they had no choice but to come out of there because their bike were right in the center of the yard. So they came out of there, and when they did came out of there, one of the girls released a rock from the back of her. And she was about 10 feet away from one of the dogs. So my wife told those girls, don't come back in here no more. There's nobody working in the building right now. I don't want you here. And they shake their head in their affirmative way that they're not going to come back. They went, got their bike, they walked, and they went by the other dog and pet him and then went home. 2 weeks later, she catch them again, but as soon as they saw the car of my wife in the yard, my wife was there already, they saw the car in the yard, they took off.
They came a second time.
Second time, they took off. When they saw her, they got afraid, they took off. There was a sign in the yard saying no trespassing.
Yeah.
On July the 3rd, 1989, they came on the property, and the oldest one got bit, I suppose, by driving her bicycle in the yard, and to get to the dog, there was a chain, a gate, and she was driving her wheel of the bicycle into the chain to tease the dog, and the dog bit her.
Excuse me. When you say girls, what are you saying here? Are they 10 years old or are they adults?
The oldest one, the one who got bit, was 13 years old, almost 14, 2 months short of 14. And the youngest one was 11.
And this was on your property? The dog was on your property chain?
On my property chain.
Yeah.
After this, apparently this happened around 10 o'clock. After this, the father of the girl came on my property, turned my dog loose, put the chain 10 feet away from the anchor, a little circle on at the end of the chain with the collar right on top, the collar buckle right on top.
Yeah.
And then he took the bicycle, let my dog go away, boom, took the bicycle of the girl and moved them 300 feet down the road, just at the end of my property. All right. And then he called me up. He called the policeman at 1:57, almost 2 o'clock. This happened at 10, 4 hours later.
Was this the daytime you're talking about?
Yeah, daytime. Yeah.
Okay.
He called the policeman, and then from there he took his daughter to the hospital. And when the daughter was in the hospital, he called me up and told me that my dog bit his daughter in the road, and will I pay the doctor bill? I says,
excuse me, is this the father of the girl?
Father of the girl.
Okay.
Yeah.
All right.
Will I pay the doctor bill? I says, yes. Will I pay the hospital bill? I says, yes, because he tells me the accident happened down the road. So anyway, the policeman came. My wife got there maybe 5 minutes after 2 o'clock. And the policeman, the minute she got there, they must have been waiting in a corner. The dog warden got there first, and the policeman right after, with 2 different cars. And the policeman gave an infraction for us to let our dog roam, right?
So the police said that your dog was roaming, but you just told me and Ed that it was tied up with a chain.
Right, exactly. And the statute read, you got to allow your dog to roam, right? I did not allow my dog to roam over here, right? Somebody else did, but I did not. Even if my dog would have got loose by himself, still he was not allowed to give me an infraction because the statute read allowing your dog to roam.
Allowing
right?
your dog. So
Right.
you didn't allow
Right.
your dog to roam. How did you get loose?
La Reflexion, the father of the girl, he's the one who came on my property and turned the dog loose to get me to pay for it. So from there on, I did not want to pay the infraction. I hired a lawyer.
Hello, folks. On the last edition, edition 4 of A Chat with Glendora, we told about a crooked law firm in Manhattan, Park Avenue law firm, Sadlerly, Stevens, Burke and Burke, and a crooked lawyer there named Suarack, S-U-A-R-A-C-K, how they made an order to show cause to the city court, City of White Plains, to vacate the judgment that Glendora got against Cecilia Masterilli, a judgment amounting to $5,020. And so they tried to get it vacated on grounds that the White Plains City Court had no jurisdiction over Cecilia because she was in Peekskill. Well, we got a lot to say about that. I'm just about to read it to you. And after they served, or you really can't say it served, after they mailed to me by overnight mail the order to show cause signed by Hansberry, and it had no affidavits in it, as the order to show cause said it should, and it had no memorandum of law in it. So I had to answer it blindly, and that was the 4th edition. I just read that in the 4th edition. Now we're up to the 5th edition. And so when this crooked law firm, Sadlerly, Stevens, Burke and Burke in Manhattan, received my opposition to their first paper, they hastily got on another one, and this time they included the affidavits and the memorandum of service, the memorandum of law. And what is this? This is 10 days after the order to show cause ordered them to serve me by October 5th. Okay. Am I just going to let this go because they're so wrong and it's obviously fatally defective? No, I'm not. I'm not going to take a chance of a default judgment against me. So I spent all day yesterday, and I do mean all day, 9 hours, refuting the 2 affidavits and the memorandum of law. So let me read you the caption of this case. City Court, City of White Plains, County of Westchester, State of New York, United States of America, because it's on the internet. Glendora plaintiff versus Cecilia Masterilli, Tabat Salako, and Officer Lewis of the Peekskill Police Force. And this is the title of the paper. Glendora shows that the White Plains City Court does have jurisdiction over Cecilia. The law in Westchester is that any small claims action can be brought in any one of 5 city courts in Westchester: White Plains, Mount Vernon, Rye, Peekskill, or Yonkers. 5 city courts. A small claims action can be brought in any one of those. So there you are. So what's that do to their argument? The affidavits and memorandum of law arrived 10 days later than October 5th in defiance of this court's order. The order to show cause is fatally flawed as to both service and erroneous content and must be quashed. These are Park Avenue lawyers saying the judgment should be vacated because the White Plains Court doesn't have jurisdiction over Cecilia in Peekskill. And then what did I just tell you the rule is? They don't know that. And the judge who signed it obviously didn't know that. Glendora is suing Cecilia. I'm suing Cecilia Suarack, the liar for hire, and Sadlerly, Stevens, Burke and Burke for the money that they have cost her with this legally illiterate paper. No way can the judgment Glendora got be vacated. Staying Glendora's collection was a miscarriage of justice. That's the gravamen of this paper. White Plains City Court has jurisdiction. The rule in Westchester County is that any small claims action can be brought in any city court in Westchester. White Plains, Peekskill, Yonkers, Mount Vernon, or Rye. A Park Avenue lawyer should know that, and Glendora told Callaghan and Satterley in 2004 in the Rye City Court. Glendora told Callaghan of Satterley, Stevens, Birkenberg. I told him that. Now, this isn't to say that he's forgotten it. The way they lie, they are a liar for hire. It probably is, or possibly is, that they chose not to remember it. But being the liar for hire they are, Satterley likely ignores this rule, hoping desperately to get by. Satterley filed no affidavit of service. Glendora's friend in White Plains, thank you, Elena Sassow, the great American hero, one of the greatest American heroes that we have. Friend in White Plains checked the file October 7th, and there is no affidavit of service upon Glendora by Satterley. Glendora could have filed in any one of these 5 city courts, but she chose the Queen City Court, White Plains, which is the county seat, as you know. White Plains is a beautiful city. A beautiful city. Why not? They have all that money from the corporations. Swarock Satterley received Glendora's $14 overnight October 12th. Learned they did not enclose affidavits nor memorandum of law, and then try to cover by sending out the same by overnight received by Glendora October 15th. That's what I just showed you. There is, of course, no apology, no remorse, no admission. These traits are reserved for the honorables in our society. Motion to vacate must be denied since the order to show cause and the service of same are totally and fatally defective. Court ordered that the order to show cause be served by October 5th. It was not until October 15th. Court ordered the order to show cause be served by first-class mail, certified return receipt requested. The October 15th packet was not. It was by overnight express. That's the October 5th one. There was no regular mail service. There never has been. So, what I'm saying here, just on the service, the order to show cause is a nullity. The order to show cause has to be served in personam. A post office box is not sufficient service for an order to show cause. And Hansberry should have known that. He should never have signed that order to show cause. If Glendora decided not to go to the post office the 15th, she would have never known until days later. Glendora answers this second overnight only to prevent judgment against her by default. And here is the so-called affidavit of Swarak, a liar for hire for Satterley, Stevens, Birkenberg. He says, I am a member of the bar of this court. And Glendora says, for purposes of appeal, Glendora demands proof. I don't believe him. Show me that he's a member of the bar of this court. And what the heck does that mean? He's not licensed by the state of New York. No lawyer is. He only has a union card from a trade union called the American Bar Association. You and I are not the American Bar Association. You and I are the state of New York. And he doesn't have a license from you and me. Okay, and then he says, Satterley, Stevens, Birkenberg, and associated with the firm Satterley. Well, I want to know how. Glendora demands to know in what way is he associated with Satterley, Stevens, Birkenberg. I am fully familiar, says Swarak, with the facts and circumstances set forth herein. Well, Glendora says this is a lie. He is not. He was not there when it happened. So you cannot be fully aware of the facts and circumstances. I am. I was there. Everything Swarak tells you is second or third or fourth hand. That is, it is hearsay. He says, and submit this emergency affidavit in support of defendant Cecilia Masterilli's motion 1 to vacate a default judgment entered against defendant by this court on August the 25th, and 2, pursuant to CPLR 50, that would be Article 50, Section 15, and subsection AD, A4, based upon the fact that this court had no jurisdiction over the defendant when it ended the judgment. What an ignorant thing to say. It's just plain ignorance. And Glendora says, again, the rule in Westchester County is that a small claims act can be filed in any one of the 5 city courts: Mount Vernon, Rye, Yonkers, Peekskill, or White Plains. Glendora chose the Queen Court, White Plains, the county seat. And Swarak says, and to stay the enforcement of the judgment until this motion has been decided. And Hansberry signed that. This should never have been granted on such an ignorant, illegal, defective order to show cause as Satterley wrote. Take note for purposes of appeal. Always in the lower court, you object. Don't say, oh, well, I'll do that later. You object right then and there. For purpose of appeal, you object. Swarak says, person in New York Code Rules and Regulations, Section 130-1-1A, I hereby acknowledge that, to the best of my knowledge, formed after a reasonable inquiry, the presentation of this motion and the supporting papers are not frivolous, as that term is defined by New York Code Rules and Regulations, Part 130. Oh yeah? Well, this is frivolous. Not only is it frivolous, it's ignorant. It's illiterate. Legally illiterate. And he signs it, and there's no jurat. He doesn't say where he signs it, and he doesn't say what date he signs it. And here is a muddled signature showing the state of his mind. A person who thinks straight would make a signature like that. Well, they are frivolous. And further, they are abominably ignorant, illegal, and defective. Glendora moves for sanctions pursuant to New York State analog to Rule 11, Federal Rules of Civil Procedure. These people should be fined $5,000 for writing such a stupid paper. Glendora demands Carmody weight proof of authority to represent Cecilia and to know who is paying for this. Do not invoke client-lawyer relationship. It is not a law. Take note for purposes of appeal. Swarak does not state that he fails to have a license from the state of New York. And all he has is a union card from a trade association, the American Bar Association. Would you go to a medical doctor, folks, who wasn't licensed by the state of New York? Would you? Licenses are not given to lawyers. They only have union cards from a trade association. Now we go on to Cecilia Mastervilli's affidavit, so-called. It hardly rises to that level. Cecilia Mastervilli, being duly sworn, deposes and says, well, Glendora questions the sworn to. If Cecilia was well enough to go to a notary, she is well enough to go to court and go to work. Cecilia says, I am a defendant in the above action improperly named herein as Socorro Masteroth. This is court error, and Glendora says, see infra. And again, I show them how clearly, folks. This was in the 4th edition. I'm putting it in your edition now. Now that's very clear, okay? There's her name, very, very clear. The same with Tabat Salako. And the same with Officer Lewis of the Police Department of the city of Peekskill. Peekskill, Pataki. Did you know that Pataki comes from Peekskill? And she says, and familiar with the facts hereinafter recited. Glendora says, what? Meaning? Relevance? Clarification is demanded. And she says, and submits this emergency affidavit in support of my motion, 1, to vacate a default judgment entered against me by the court on August the 25th, 2005, the judgment. And Glendora says, why did you not appear? Why did you not defend? Cecilia, why didn't you appear? Why didn't you defend? You were clearly in default, and it is a done deal. You had 2 months' notice. She knew 2 months beforehand, and even before that I filed a complaint back in March. And this was August they had the hearing. Then you wait 35 days after the judgment is entered. What court can be solicitous of that? Tell me. And she says, pursuant to CPLR section 5015A4, based upon the fact that this court had no jurisdiction over me when it entered the judgment. Does Cecilia know the civil practice laws and rules? Does she know Article 50? Does she know Section 15? Does she know subsection 4A4? And she's signing this? Is it likely that she knows those laws? Is this not a phony affidavit? I didn't bring this out to the court, I'm just bringing it out to you. Glendora says wrong, ignorant, and illegal. A small claims action can be filed in any one of 5 cities in Westchester, White Plains, Rye, Mount Vernon, Yonkers, or Peekskill. Glendora chose the Queen City, White Plains County seat. How many more times do we have to say this? And Cecilia says, and 2, to stay enforcement of the judgment until this motion has been decided. This motion is going to be decided this week. The motion is probably decided already on the basis of payment, perks, politics, and power. And Glendora says there was no basis, legal or factual, to grant this stay. Glendora takes exception for purposes of appeal. Her civil rights were abominably violated, abhorrently. Abominable, abhorrent, disagreeable, unpleasant. Purportedly, okay, is a dodge, a cover-up, a clandestine, a surreptitious, a fugitivism, purportedly served. You know very well she was served. A liar for hire. Cecilia says plaintiff purported to serve notice of her claim upon me by mail at my regular place of employment, which is located at 1053 Park Street, Peekskill, New York. Peekskill is not located within... Now this is another ignorant and stupid. In small claims court, the plaintiff does not do the service. The court does the service. So here's a liar insulting the court upon its service, saying, court, you didn't serve it to me right. You served it to me on my business address. You didn't serve it to me at home. Now, is that a smart thing for a lawyer to do to the host court? Say, you're wrong, court? No. And Glendora says, relevance? Plaintiff never attempted to serve me at my residence. Well, first of all, the plaintiff didn't do the service. The court did the service. And second, who said anywhere in the Small Claims Act that she had to be served at her residence? The law says served at their last known business address. This is more ignorance and desperation because of no meritorious defense. See, they don't have a meritorious defense, so they look around for all these excuses. Service and no jurisdiction. That's what, you want to be a defense attorney? That's the only 2 things you have to know. Jurisdiction and service. Never the merits. Service of the small claims action upon Cecilia was by the White Plains City Court. So these abettors are saying service by the host judge was wrong. And that is not so smart. We're up to page 17 out of 32. In small claims, service to a residence is not required. Service was to Cecilia's last known business address. Nor did Satterley, Swarak, Cecilia serve Glendora this nescient order to show cause at Glendora's residence. They didn't serve me personally with this order to show cause. In small claims, Cecilia plaintiff does not do the service. In small claims, comma, Cecilia, I'm talking to you, the plaintiff does not do the service. So abase and abash the court. Cecilia says, I have a complete and meritorious defense to plaintiff's claims. Glendora says, then where was it the night of August the 24th? If you had such a meritorious defense, where was it the night of August the 24th? 4 p.m. Well, it's too late. You were in default. You had your chance and you chose to flee. No other request for this or similar relief has been made to this court or any other court of competent jurisdiction, said Cecilia, and Glendora says the White Plains City Court has competent jurisdiction. Premise fails, argument falls. You lose. Cecilia's argument about jurisdiction is incompetent. Cecilia Swarak Satterley, abettors, accomplices, accessories are totally without a meritorious defense and totally without power to perform. Intellectual, legal, moral, spiritual, or physical. They're totally without power to perform. These pages are affectionate, they're stuck on each other. Now, this was notarized in Putnam County. Cecilia lives in Westchester County. Cecilia lives in Ossining. If she's well enough to go to Putnam County, she's well enough to go to work, and she's well enough to go to the court. Notary Nastasi is in Putnam County. Cecilia lives in Westchester County, Ossining, and if she was able to go to Putnam, she was able to go to White Plains. Neither Swarak nor Cecilia has acted in good faith. Glendora knows Cecilia's signature, and she did sign it. Neither Swarak nor Cecilia swears under penalty of perjury they are telling the truth, the whole truth, and nothing but the truth, so help them God. Glendora does, that she is. Glendora demands that Cecilia appear in court October 19th unless this court vacates the order for us to appear in personam October 19th. I do not want to go to court October 19th, and there's no reason I should. There's no reason a bunch of lawyers should poison this court. I want to stay home on October 9th because 2 years ago, October 9th, Franklin died at 8:05 p.m. And I want to be with him. Glendora moves the court to vacate the October 19th appearance. These three have acted frivolously, dishonestly, and dishonorably. 260 miles at $2.89 a gallon would be prodigal conduct by this White Plains City Court. On such an ignorant and baseless paper as this order to show cause. Let Glendora's collection proceed. Now, here is the memorandum of law, and really, folks, it just repeats and repeats and repeats what you've already heard. They're wrong that the White Plains City Court doesn't have jurisdiction, and it's totally frivolous to say that the service had to be at her home. Small Claims Court doesn't do that. So, even though Glendora makes some very good statements in here, and great refutations, it's ho-hum, because it's the same thing that you've heard. Okay, it is patently and obviously and fatally defective. Glendora prays for these people that they be the great human beings that they can be and earn an honest living and be proud of their lives. How can they be proud of these miserable lives they are conducting now? They have asked in bad faith, they have acted in bad faith, and Glendora has acted in good faith. If Cecilia Swarak Sadley had not cheated and acted in bad faith, if above this they had included the affidavits and memorandum of law, ignorant as they are, in the October 5th received packet, Glendora could have answered from them on October 6th and had these 26 pages into the court, and the court would, in good faith, cancel the October 19th hearing, saving 1.5 days and 300 miles. Glendora will be suing these three for the injury that they have done her with this erroneous order to show cause. Complicity and common guilt are implied. They abetted, they aided, assisted, countermanded, incited, instigated, connived at, egged on, fomented, upheld, helped, seconded, sustained, supported, advocated, encouraged each other. They are abettors. They are accomplices. They are accessories before the fact and after the fact. They have damaged Glendora severely. Up here in the country, no mail moves after 12 p.m. Saturday. It's 11:25 a.m. There will not be time to finish this. Writing it, printing it, I'll say it took until 8:15 in the evening. Do 16 envelopes, collate, staple, label, stuff, and seal, and post, and read it on TV and the internet by noon. Glendora's Social Security money and Franklin's pension are all used up for this month. Where would she find another $14 for the court and $14 to Satellite to mail it overnight? Glendora requests again this court cancel the October 19th hearing prima facie on this erroneous, illegal or argument on fatally defective service. If this paper does not get to the court on time, for this Glendora is the plaintiff and speaks first and demands to read this 28 pages as her opening statement and get it into the record. The minimum that you can get from a court is an opening statement. And remember, the plaintiff speaks first. George Dixon doesn't know that in the Chatham Village Court. Prologue. The order to show cause why the judgment should not be vacated has been answered. The judgment should not be vacated. The order to show cause fatally defective as to service, as to fact, and as to law. It is. It should never have been signed by the court. Cecilia Swarak Sadley should be sanctioned and fined for wasting scant judicial resources and Glendora's scant resources. Collection must proceed without impedance. Isn't it awful? And these are the mail receipts. And here is the mailing list. Isn't this pretty? I'm closing it with a green page. And you see Bob Hope in green? $1957. Was that 50 years ago? 2 years?